Jules, welcome back to the show. Before the break, we were talking about how these two experts in workers' comp and TAC could help me if I was an injured plaintiff. The last thing I want to ask them is, assuming you've settled a common law claim for me, John and Don, what else can you do for me?
Tony, every worker in Victoria, in Australia actually, has a superannuation account benefit. It's compulsory. Now, as part of that, there's usually a total and permanent disablement benefit.
It's an insurance component.
Exactly.
Which can be substantial too, John.
It could be $100,000, could be $200,000. In that regard, you don't have to show that it's a work injury that stops you from work. All you have to show is that your medical condition has now stopped you from work permanently. If that's the case, you can make a claim for that benefit.
Don, what John was saying was that assuming my work injury was a back or a neck, you can throw everything in there, high blood pressure.
That's right.
Stress, depression.
In my area of practice, I mean, people aren't injured at work. That's why it comes on the Transport Accident Scheme. If those people are prevented from returning to their work, if they're working at the time, they're entitled to this TPD, or total and permanent disablement.
And usually you have to wait, what, 6 months? You've got to be off work for 6 months?
Well, a lot of it depends on the actual terms that they use.
At the minimum.
Yeah, but 6 months is generally the minimum.
Okay. So I'll get a common law settlement, and there's the contributions on the superannuation, plus there's probably an insurance component to my policy.
Exactly. And usually it's the same as the death benefit component, isn't it, Tony?
It is, it is. And I've heard cases where the superannuation component's higher than the common law damages settlement.
Exactly.
Is that fair to say?
Yeah, we can.
Exactly.
And it just has to be a policy that's in place at the time that you stopped working, so when you're at work.
And Tony, there are people that have multiple superannuation accounts.
Oh, that's right.
3 or 4. I've got a client at the moment where we've got 4 superannuation policies in place, and there's 4 multiple claims.
So you can claim all of them?
Exactly.
Okay. All right, John, tell us about this momentous decision of Georgopoulos again.
Mr. Georgopoulos, Tony, Court of Appeal has recently found that in essence, a worker, once been granted a serious injury certificate to sue the employer for common law damages, can rely upon not only one body part, but multiple body parts in the action.
So everything that's gone wrong because of the accident, you can claim?
Once you've been given the serious injury certificate, a worker has been given the serious injury certificate, it's the gateway, Tony.
That's it.
The worker
the other thing the Court of Appeal highlighted was this. Don't you have a problem that if you apply for 2 serious injuries, assuming the serious injury was a psych and a back, and you only got it for psych, the defendants, the first thing they'll cross-examine you on is, in your affidavit, you say you can't work because of your back. Chance of you getting loss of income for your psychiatric condition would be pretty limited, wouldn't it, Don?
That's right. And I think the whole Georgopoulos just brought back what we knew the serious injury test was, and that is just purely a gateway provision.
Exactly.
All it means is getting the permission to go ahead and start your claim for damages. The respondent or defendant in this case, what they were arguing was just going to lead to ludicrous results. It was going to lead to multiple litigation. It was going to lead to confusion throughout the whole scheme. I mean, when I first started, all we knew was serious injury was the gateway, and that's been the TAC, for example, has been around 25 plus years.
That's right.
Exactly. 1984.
So what the defendant tried to do is just try and change the whole way we knew that the system worked. Even the government knew the system worked.
And just on that point, John, the Court of Appeal said that one of the vagaries of interpreting the legislation like that is that someone that was quadriplegic could probably get a worse result than someone that's got multiple injuries who could lodge multiple claims and potentially get a maximum for each body part.
Quadriplegia, the maximum for economic loss, for example, for loss of wages is a bit over $1.1 million. So that person who's a quadriplegic would only get $1.1 million maximum. Whereas another person that's got an injury to a leg, a back, and maybe loss of an eye, they potentially could get $1,100,000 for each of those injuries. It was going to be a ludicrous result, Tony.
The reality is they never get it, but what it'd do is multiple claims, multiple costs. In the end, who would pay for all this?
But Tony, the Victorian taxpayer and the system would have broken down. We don't want that to occur. We want people to have common law entitlements to sue for lump sum compensation. And that's what a worker can do for the body parts that have all been injured by the work injury.
All right, let's try and give a balanced account. WorkSafe wanted to limit your damages just to psych. So in effect, if the claim's worth $200,000, they'd be offering you 70 to 80,000. Dom?
That's
correct?
Yeah, that's right. That's right. Because
that's
they wouldn't be able
reality.
to take into account, for example, the back injury.
Why isn't that a good move? Because it means that there's more money in the system for everyone else.
I think it wouldn't be, Tony, because like I said, it will just lead to more litigation, which will cost the taxpayers more money to fund it. I mean, ultimately, you'll be running 3 or 4 cases
Per person.
separate per person, where you could just done one application, one court application, and heard determined all at once.
And Tony, to recap, a worker that's injured in the course of employment at work can lodge a serious injury application after the 18th month mark anniversary of the date of injury.
And
Now, and as I said previously in this show, if your lawyer has been sitting on your case for 3-4 years, you should be asking them the hard question.
And for transport accidents, you just can start pretty much, the minimum is 3 months. So you can start as soon as 3 months after the accident.
Is there anything else you want to add, Don?
Well, look, it's quite important always to get started straight away, particularly in transport accidents, because a lot of time we have to investigate the circumstance of the accident. You got to get the police reports, things like that, and speak to witnesses. You want to get to them straight away, and also start getting all the medical evidence straight away. So quite important. If the lawyer's lagging with your claim, you should ask those questions.
John, anything else you want to add?
Tony, workers' lives are seriously affected by these work injuries. I don't like the situation. I don't like hearing stories where lawyers are sitting on cases for 4 or 5 years. You need to action it now. And if your lawyer isn't communicating with you and telling you what's going on, maybe you should look elsewhere.
Viewers, you've heard it from the experts. So thanks for watching. John, Dom, thanks for coming on board.
Thank you, Tony. Thank you, viewers.
Please stay tuned for future episodes and always stay safe.